trigger trust is an asset protection trust that has the most favorable components of the domestic asset protection trust with the tremendous strength and track record of the foreign asset protection trust. It is much easier to operate than the traditional domestic trust because the settlor is often an initial trustee. There's a protector in place, and when there is an event of legal duress, the protector can elect to pull the trigger to erect the armor plating of the foreign asset protection trust. Now, the trigger trust is a certified and registered asset protection trust from day one. The trust has an international registration certificate. The verbiage is in place to enact the powerful offshore asset protection trust verbiage. The client supplies the legally required due diligence to meet the Know Your Client regulations, and the foreign trustee is in place up front and plays a passive role initially. So once the legal threat arises, it only takes a matter of moments for the protector to engage the legal weaponry of the offshore trust. Tax matters. Now, for those with a technical knowledge of the tax aspect of the asset protection trust, this section is for you. If it's a U.S. client establishing this structure, the trust is initially a U.S. trust for tax purposes. It will have a domestic trustee, often the client. It will be under U.S. court control. As such, there's no need to file the foreign trust tax forms. At this stage, there is no need to file a separate tax form for the trust or get a separate tax ID number. The trust simply uses the Social Security number of the client, and the IRS considers it a domestic grantor trust. Now let's address the word trigger. The IRS does not recognize a trust as a domestic trust if there is an automatic triggering mechanism that converts it into a foreign trust. So the trigger is not automatic. The conversion requires human intervention. That human intervention usually means telling your protector or trustee that you have encountered legal duress. So once so informed, the trustee/protector will take measures to enact the offshore trigger. Simplicity. Because of the simplicity of this trust, it is as easy as using a living trust. It's easy to open a bank account in the name of the trust, and it's also usually easy to make arrangements so the trust owns 100% of a limited liability company. So in the event that legal waters get rough enough, the foreign trustee can step in to protect you, and you have a vehicle inside the trust that you can operate your business and investments. You also have a bank account in the name of the company that's owned by the trust with a couple $1,000s in it. So you have an open baseball glove to throw the ball into it the same day you need it. Keep in mind, a lawsuit can get a lis pendens on real estate and can freeze domestic bank accounts. So by having an offshore account in place, you have an immediate place to wire the funds should you need to. Then, once you're convinced that you're losing the legal battle, likewise, you can have your trustee step in and take protective measures for the trust-owned company as well. The trustee, incidentally, is a licensed bonded attorney group based in the Cook Islands south of Hawaii. Cook Islands is a self-governed jurisdiction under free association with New Zealand. And as such, it has a very stable, well-regulated, safety-conscious legal framework. There are multiple safety barriers in place to protect client assets and to ensure the integrity of the financial services industry. Statute of limitations. Why age is important. The age of the trust is important. There are several statute of limitations that give the trust stakeholders powerful legislative protection. That is, once the trust is established and funded, your opponent could not successfully transfer your transfer of assets into the trust even if they so desired. This time frame is as little as 1 year in the Cook Islands, typically 3 to 5 years in the U.S., and 10 years in bankruptcy court. So starting and funding the trust now means that you start that clock ticking. Moreover, in the Cook Islands, there are significant barriers in place from the beginning. In the rare cases where the plaintiffs are able to transfer the lawsuit to that jurisdiction, prior to the statute of limitations time frame, it's very difficult for your legal enemy to get the courts to view the case from his or her perspective. This is because the barrier of proof for your opponent is beyond a reasonable doubt. Now, the age of the trust starts from day one, not the day it was converted to a foreign trust. So let's say that again. The statute of limitations on the fraudulent conveyance clock starts ticking from the day you form the trust, not the day the trigger is pulled. So once the requisite time frame has expired, accusations that you created the trust to fraudulently deprive a creditor will fall on deaf ears. The courts will refuse to entertain such an accusation. So what do most people want? Most people want the most powerful asset protection to thwart off a legal attack. You work hard for your money, so if somebody sues you, you're going to want them to work a lot harder. So the trust gives you virtual control from the beginning to end. That is, it puts you in the driver's seat when the legal atmosphere is calm. Then when the litigious hurricane begins to stir in your life, the terms of the trust, which you yourself agreed to, kick in to protect you. Experience. Now, this organization has been operating since 1977. We have well over 40,000 clients. I've personally been in the business for 26 years as of this recording. So it is our experience that this trust works. We know of none of our clients who have lost money with funds housed in a properly established and operated offshore trust with the trigger mechanism in place. So if you would like to get more information about the trigger trust, you can go ahead and give us a call at the number on your screen or visit us at assetprotectionplanners.com. Thank you.